All the second stage tanks now pressurized. Astronauts report it feels good. T-minus 15 seconds. Guidance is internal. 12, 11, 10, 9. Ignition sequence start. 6, 5, 4, 3, 2, 1.
Like a furry torpedo to the jugular. This is Honey Badger Radio. Radio with bite.
University Title IX Department personnel. Are they all toxic?
Best way to find out is let them all bite you and see which bite you die after.
If you've ever worked for a corporation, you've probably had some dealings with their human resources department. Maybe you've had questions about your insurance benefits, had to take leave from work, or needed additional information when filing your taxes. Often, these are handled by human resources departments, but they're not the department's main function. That is to keep their employer, your employer, from being sued. The easiest two ways to find that out are to have a complaint that merits human resources processing, or to be the subject of a complaint whether it merits human resources processing or not. Suddenly, you are the fly in your workplace's ointment, and while the process you go through to resolve whatever complaint has been made will seem as straightforward as it can possibly appear, you'll soon find the ultimate goal is to preserve the ointment by removing the fly. Your only protection is the same as it ever has been. Keep your head down, follow the rules, document everything. Save every scrap of paperwork you receive, including your copies of any evaluations you've gotten, and always be recording. It won't save your working relationships with your colleagues. It can prevent false accusations from leading to a full investigation, but not always. It won't necessarily preserve your job for very long if you are accused or have to make a complaint, either. What it will do is make it hard for your employer to get rid of you before you find another job. It may provide you with the evidence you need to sue for compensation if you've been illegally mistreated by your employer. What does this have to do with Title IX? Title IX has created a university administration to student equivalent of the lawsuit prevention function of corporations' human resources department, and it comes with its own kangaroo court system. When a complaint is filed, the institution's Title IX coordinator and staff do not know who is honest and who is lying, and they don't care. They only know or care that their handling of the situation is the only thing that stands between the university and a discrimination lawsuit. In the end, that is likely to be their only concern. Historically, this has meant bending over backward to accommodate female accusers, but protect accused women, per the ideological guidance of the Gender Studies Department, as women were the individuals most likely to sue over the outcome when it didn't meet their expectations. That was exacerbated by the guidelines laid out in the Clery Act, the Dear Colleague Letter, and the Campus Save Act, which all were written to mostly presume victims would be women, to mostly presume perpetrators would be men, and to mostly exclude the presumption of innocence from universities' Title IX hearings. With Education Department guidance and aspects of the law supporting female and only female accusers rather than due process, it would seem safest for the university to assume that female dissatisfaction with the process would be more likely to lead to university liability than would any dissatisfaction expressed by the men, especially accused men. These standards resulted in a tidal wave of incidents in which accused students were railroaded through egregiously biased, unbalanced, and incompetent university tribunals following accusations that should have been handled by real law enforcement. Jonathan Taylor of Title9forall.com, who has been tracking this phenomenon, has noted over 200 lawsuits alleging due process and related claims against educational institutions in the wake of their kangaroo court hearings. The lower courts have already begun to find against universities in some of these lawsuits. Among other legal points, judges have ruled that accused students have the right to face their accuser, and recently 2 courts upheld an accused student's right to cross-examine his accuser. Some institutions, like the University of Southern California, are facing multiple lawsuits by male students deprived of their due process rights or otherwise discriminated against in the course of Title IX complaints. Students have won judgments against universities for such violations, and judges have forced some institutions to provide plaintiffs in lawsuits against them with their Title IX training materials for examination. It is becoming obvious to administrators at this point that they cannot just presume a Title IX complaint true or valid and go from there, nor can they bias their response depending on the sex of the accused versus the sex of the accuser. Throwing male students under the bus to defend against the wrath of female students will not protect their institutions from repercussions should their procedures and policies, or their administration of them, be unfair. With their cookie-cutter solutions becoming problems in and of themselves, Title IX administrators and their subordinates are scrambling to figure out how to handle the cases arising from sexual misconduct and harassment allegations without making their employers vulnerable to more lawsuits. As a result, they are now consulting with attorneys who have handled some of the lawsuits caused by university mishandling of conflicts on campus. The Rowan University Title IX Conference offered a presentation on this very subject, how to avoid a Title IX lawsuit, lessons learned, and best practices for respondents. Tonight, we'll be looking through the slideshow for this presentation as our undercover badger explains what was discussed by the presenter. Hello and welcome to HBR Talk 47, Title IX, Targeting Men for Whose Protection? I'm your host, Hannah Wallen, here with that adorable specter of death, Prim Reaper, and our undercover badger, Andrew, who has infiltrated academia cleverly disguised as himself, to continue discussing his observations from the recent Title IX Research and Resources Conference at Rowan University, with a look at their presentation on avoiding lawsuits created by attorneys who have represented respondents who have been treated unfairly in campus disciplinary proceedings. And speaking of being treated unfairly, before we get into today's topic, you gotta listen to a shill. If you're on YouTube and it starts experiencing platform malfunction syndrome and won't let you listen, we're also on Twitch and Facebook because you can't keep a good badger down. If you want to be sure you'll always be able to catch our live streams, even if YouTube decides to throw us in the gulag for wrongthink, and apparently one of our channels is still in there, even though I thought we were out. But I guess, well, mark your calendars, guys. August 16th, 2018, a woman admits she was wrong, live on Honey Badger Radio. Anyway, if you want to catch our show in its audio format, remember to go to badgerfeed.com and register to receive notifications, so you'll find out about everything the rest of the internet won't tell you. So, let's talk lawsuits. No, not ours. That'll be tomorrow with Karen. Come on, guys, let's give the presentation a look. We'll start here with this title page that has the name of the presenter and the title of the presentation here: How to Avoid a Title IX Lawsuit, Lessons Learned and Best Practices from Attorneys for Respondents. And these are apparently the attorneys who helped to create this. So these are folks you might be able to turn to for help if you have been treated unfairly in a university tribunal or investigation.
Yes, this particular law firm represented the respondent, or the student who was accused in the Brandeis case.
Okay.
So
definitely
they definitely could do their thing.
They could do their, and they would definitely be somebody to consult with. Obviously, yes. Not everybody can go to that particular attorney because this is happening all over the country, and unfortunately, not everybody can travel like that. And of course, attorneys can't necessarily travel like that. But the other thing that I've noticed is, if you know one attorney that is an expert in a particular area, a lot of times they can recommend either somebody in your area or somebody who might know somebody in your area who can do what they do in their area. So moving on to the next slide, this gives their credentials. It explains a little bit about who they are and what they've done. Because the print's really small, I'm just going to read this out. Patricia M. Hamill is the chair of the Title IX Due Process and Campus Discipline Practice at Conrad O'Brien. She represents college students nationwide, and more recently college professors who are subjected to campus disciplinary proceedings or who have been disciplined by their colleges for alleged sexual misconduct following such proceedings. And I'm sorry if you guys can hear my jaw popping. I'm trying to make it stop and it won't. Apologies, guys. I'm old. Ms. Hamill often attempts to resolve cases behind the scenes. Where resolution cannot be achieved, she has filed lawsuits for breach of contract, violation of Title IX or other civil rights statutes, and tort liability on the basis that colleges' investigation and adjudication discriminated against or procedures failed to ensure the students' fundamental due process rights, discriminated against them on the basis of sex, and breached the school's contractual obligations. Notably, Patricia was the lead attorney in Doe versus Brandeis in the District of Massachusetts, one of the most often cited cases in this area. Outside of the Title IX arena, Patricia is a commercial litigator who also represents clients regarding government investigations. So, you go up against the government, you have to really know your stuff. They say you can't fight City Hall. You can, you just need a really big dog in the fight. And let's see, we have, I believe that's pronounced Dakessian. Laura, I might have that wrong. Laura Dakessian is the vice chair of the Title IX Due Process and Campus Discipline Practice at Conrad O'Brien, PC. She represents college students and professors who are subjected to campus disciplinary proceedings, and this is pretty much the same as the other one. She works closely with students and their families to help them navigate and fully prepare for investigations and hearings, and is experienced with working with students whose situations may be complicated by mental health concerns or the need for disability accommodations. In addition to her representation of college students, Lori represents clients in several practice areas, including white-collar and internal investigations, complex commercial litigation, and data privacy matters. She also is a certified information privacy professional, the global standard for privacy certification. So they both come highly recommended, and so this ought to be a really good presentation.
It was. Yeah, they're based out of Philadelphia, that particular practice.
Well, they've got their work cut out for them then. Yeah. No wonder they're so good. You gotta be to survive in Pennsylvania. Yeah. So the next card just gives an overview. Says we're going to go over the current environment. They're going to give a brief overview on Title IX. They're going to give an overview on Title IX litigation. They'll discuss the disciplinary process from complaint to appeal, and then they had time for questions.
Yeah, so during this, they just gave an overview, is that they wanted to be a resource to the Title IX professionals, we'll call them, who were attending the conference, that this presentation wasn't necessarily coming from one side or the other, but based on their experience with mostly representing students who have been accused of sexual assault or any other type of Title IX violation. They have a lot of experience in that area.
Yeah, and at the very least, what this tells us, just from the beginning, is that colleges are going to change their behavior based on not wanting to deal with any more of these Title IX lawsuits.
Yeah, because they get expensive.
Yeah, and I think some of them are going into these lawsuits now knowing they're going to lose, because previous rulings have demonstrated that the courts are not excusing universities from due process procedures and due process standards just because they're not part of the court system, because they are handing down some pretty harsh punishments to hand down to a student who is innocent. For guilty students, the guilty students are getting off easy, frankly. especially, well, at least those that are guilty of criminal offenses, but especially those that are guilty of violent offenses. They're getting off easy because all they're getting is told, well, you can't do this one thing, and that's not that big of a deal when the alternative is jail. But it is a big deal when the alternative is, because you didn't do anything wrong, nothing is being taken away from you. So I can see why universities aren't being let off by the courts, and it's interesting to sort of see how the universities are responding to that. So with that, we're going to skip the next thing and go right to the slide labeled "What's at Stake?" And I noticed they featured Brock Turner because...
Well, and they featured
because of
Brock
course
Turner.
they would.
And the fact that that's in a college textbook.
Yeah, the poster child for feminism's. Yeah. Oh my gosh, rape culture.
Yeah. So, but they talked about during this time that sexual, like in a world where we previously really didn't talk about sexual assault and misconduct, it's important that colleges and universities are being aware of it and that they are having conversations about it. But on the other hand, responding students can go through a life-altering process even when found not responsible, and it's also important for colleges and universities to be sensitive to those students as well, is basically what they were saying here.
Well,
what they talked about. That wasn't like in the PowerPoint itself.
Yeah, it's good that they've started figuring out, they've started getting universities to understand that it's not just the accusers that they need to have consideration for. They have to have consideration for the accused as well. It's interesting that they used the Brock Turner case because that's an interesting case in and of itself. I mean, here the details of the case. A lot of people don't realize the details of the case because what was genuinely widely reported was that two guys found him in an alley fingering an unconscious girl. What they didn't report was that was away from the party, that she had spent the evening at the party, that they had been drinking together, and that they had been walking together to his room, and they ended up in that alley instead. And so I have all sorts of questions on that one. Like, he didn't knock her out and drag her to the alley in front of all the other people at the party. He didn't knock her out and carry her to the alley in front of all the other people at the party. And clearly that means that she must have walked there on her own. So why would you go back to a drunk guy's dormitory with him when you were at a party like that? In the middle of the night? What purpose would you have in mind when you'd be on your way to this drunk athlete's dormitory room? Because, I know I was in college twice, and I didn't go hang out in guys' dorm rooms alone with them when they were drunk for any other purpose but to engage in sexual activity. So I understand why the judge believed him when he said that he had prior consent. And even though the jury found him guilty of sexual assault, not rape, but sexual assault, the judge gave him a lighter sentence because the judge believed that, yes, he did have prior consent. And so what he was actually convicted of was not noticing when his drunk sex partner passed out because he was equally drunk.
Yeah, I was gonna say, sure, you can do things that you might not otherwise do when you were blackout drunk, but if you're the one who is putting all that alcohol into your body, then you still got to take at least some responsibility, right? He wasn't putting it into her. They were drinking together. They were both being college students together. And I know I've done that before in the past, and I don't know, I felt bad about over drinking the night after, or the morning after, but it was still a thing that I decided to do. And
this is
I
one
guess
of the things
I guess I didn't go back to anybody's dorm rooms, but you know what I mean.
Yeah, it's one of the things that bugs me about feminism on women's behalf, as much as on men's behalf. there's a thing that happens periodically. You hear a news story here and there about it every so often. Somebody high school or college age decides to challenge alcohol to a duel, and alcohol kills them. And you can drink so much and then you pass out, or you can drink so much and then you pass out and you have additional health problems. And like, one of the things that happens with gals is they just assume they should be able to keep up with the guys drinking. And no,
metabolism is very different.
Well, yeah, it's not just metabolism. It's a combination of things. Like, there's your metabolism, your weight. There's the fact that our bodies are different on a fundamental level, on a cellular level. So
alcohol actively affects women stronger than men. Like, they don't have the same levels of the chemical needed to break it down properly.
Exactly. So. We're like that with a lot of things. Our bones are not as dense as men's bones either. It's why you don't find very many women playing tackle football in the United States, because women are more likely to have broken bones from that game than men are. And young men do get their bones broken. Boys that are still in high school get their bones broken in football games. Girls try to keep up with them, and they get crushed. And then, of course, there's the other thing. Different genetic backgrounds can make a difference in how well you can handle alcohol. So if you get a girl with a genetic background from, folks that didn't have to drink as much alcohol because they actually had good water in their country for the last several centuries, they're not as likely to be able to keep up with a dude whose ancestry comes from a country where alcohol was a substitute, because they didn't have good water in their country for centuries. And, your body is a result of the evolution of your ancestors, right? So you have these situations where every so often you see it happen with a guy and it makes the news, and every so often you see it happen with a gal and it makes the news. And when gals try to keep up with guys in their drinking, it results in disaster. And feminists want us to ignore that disaster, or to act like it's the guy's fault. We can't be responsible for our own actions and our own decisions. Like, we're victims of our own choices. We're not victims of our own choices. We are the makers of our own choices. And young women should hear that they are responsible for what happens to their bodies when they get drunk. And even if we're talking about the fact that they have made their bodies vulnerable to the whims of a criminal, it's still their responsibility to not do that. The criminal might be responsible for his actions, but you're responsible for putting yourself in that situation. And young women would be much safer in the world if we learned, as women, as girls growing up, to take the same responsibility for ourselves and our safety and the people around us that boys learn to take growing up for themselves and their safety and the people around them. Yep. So my ire with the Brock Turner story, you hear me going off on it. It's partly because of that feminist mentality of women being victims of their own choices, and it's partly because he was treated unfairly, and it's partly because people showed up in the Dayton metro area with firearms that can shoot through brick and mortar to protest his getting to go home. That kind of pissed me off. So yeah.
And then the quote from Betsy DeVos at the bottom saying no student should be forced to sue their way to due process didn't make these feminist types happy.
Oh, I'm sure they were probably thrilled to hear that. Did they say anything about that indicated that they think it's not due process for the alleged victim if the accused gets due process?
Well, they really didn't talk about this, but I do have a side story related to this presentation. The presentation that I went to after this one, it was some sort of bystander intervention or something, but one of the people from the Women's Center, and then somebody else, I think she was some professor, I don't know, I didn't recognize her, they didn't like this presentation very much. They were kind of complaining about it.
Oh,
and then I came in the middle, like listening in the middle of the conversation, and they were talking about how the entire campus is a men's space. Why can't women just have their women's center or whatever? And I'm just something stupid like that. Like, this is why your degree in gender studies is teaching you an ideology and indoctrinating you, not actually.
This is one of the things that I actually, there's a lot of things I hate about feminism. This is one of the things about feminism that kind of disgusts me. They treat everything like a zero-sum game. If it is not only for women, women are supposedly excluded from it. And it's like, just because something isn't for only women does not mean that women cannot be involved in it, cannot participate in it, cannot enjoy it, cannot change it, cannot basically have their own impact on it and be a part of it. It's really, I don't know. It's as though they treat men as an alien species, and therefore anything that men touch is somehow alien to women. And if they don't basically exclude men from it, then women can't consider themselves part of it. And that's like the opposite of the way human has had its success in history. Everything that we've done in history as a species, everything that we've succeeded at as a species, has involved cooperation between men and women. It's not involved subjugation. It's not involved of one sex or to the other. It's not involved mistreatment of one sex by the other. It's been a contract between the sexes. And we may have done things differently in history than people today would like, but it worked. And the idea that we should now suddenly treat each other as two alien species sharing the same planet and fighting for space, I hate that. I just absolutely hate that. I love other women and I love men, and I would like to see everybody work together, and I would like to see us all be able to share the communities we're in together and continue to have success as a species. But it just drives me nuts that this is happening.
Well, not to mention it kind of totally goes against their whole, all we want is equality thing. It's like, no, you want to be entirely separated from men half of the time.
Yeah,
especially when they scream things like the future is female or whatever.
Yes. It's like, okay, can I just take a hard pass on that, because that sounds completely miserable.
Yeah, I don't want a one-gendered future.
No.
So, basically, they figured out, and they've got this as the title of two different things, they figured out that what's at stake is lawsuit after lawsuit after lawsuit. So they had what's at stake as this one, and then what's at stake here as the next one. And it says here, Commentary Magazine, the campus sex crime tribunals are losing. And there's an article. The Atlantic, the uncomfortable truth about campus rape policy, September 7, 2017. So those are both in September of 2017. And there's another link. The Wall Street Journal, Witch Hunt on the Quad, January 27, 2017. And that one's also... I think that one's behind a paywall, because if I remember right, the Wall Street Journal is behind a paywall, but I'm sure it's probably also archived. But
Probably.
that's recent stuff. I mean,
Yeah,
these
'cause
things have gone back more than 10 years.
Yeah, and during this slide, they were talking about how a lot of the judges in these cases are just dumbfounded at the lack of due process that has been shown, and that they're confused about the system that the colleges have set up, because they're used to their courtroom and having certain rules, and that they don't live in the Title IX world, and that basically they said to the Title IX people that the more that you can show your process is actually fair, the less likely you are to face litigation or lose a lawsuit.
Well,
So they have to be careful about how they do things, pretty much.
And that makes sense. I mean, the moment that you do something that is overtly unfair, you open yourself. It's all actionable. Thing is, I'm sure that your subjects, I don't necessarily know if they were women or not, but the folks that were feminists that did not like this presentation were probably sitting there thinking, if they have to be fair, that means more people are going to be found not responsible.
I think like 90% of the conference attendance was female, so...
Yeah. Well, that's not surprising either. I think most people who work in this area are going to be female. You aren't going to see as many men taking the organization route to dealing with this kind of thing. I've noticed two kinds of responses from feminist men on this. You have the "I'm a good boy, I wouldn't do that" kind of thing feminist. Oh, all the other men are bad, but I'm good. That feminist man. And then you have the aggressive male feminist who just wants an excuse to beat somebody up, and this gives him one. So I'm sure there's other kinds there, but in response to this particular subject, they seem to fall into those two categories. The one good man and the guy that sees this as an excuse to take out his aggression. Not that that's limited to guys. There are aggressive female feminists that are even worse.
I will never understand that kind of thought process where it's like, I am the only perfect angel individual in the world, and everybody else is the one that's flawed. Like it just doesn't make sense. It speaks to a fundamental lack of understanding of other human beings. Like, how self-centered can you possibly get? I don't understand the people who aren't fully aware of that kind of thinking. Like it must be just like a mental state that I just can't comprehend, because it's so far beyond what constitutes rational behavior in my mind. I just can't even get it.
Well, they're femme shady. They're the real femme shady. All you other femme shadies are fat, dumb, and lazy. So with the real femme shady, please stand up for women.
God.
I had to. I'm gonna. Yes, I'm going to forcibly insert a couple of our super chats in here, just for the record, because that's just the kind of girl I am.
But none of them are being internet violence at you.
Yes, that's right. None of them are being internet violence at me. So Joey Jojo gave us $5 and said, "Stuff like this makes me glad I am incel. I can drug away my need for contact. I have porn to wish I could drug my need to pair bond to." Well, you don't necessarily have to drug away your need for human contact. The best thing to do is to be picky about human contact, and that's a totally different thing. And you got to be focused for a while on yourself. And that's it. I keep saying that. I'm going to beat the same drum every time you say this stuff, so you might as well get used to it. Frenchinator 2 gave us $5 and said, "Most men say they were, quote, being stupid, end quote, when he gets blackout drunk." And yeah, that's pretty stupid. When the way I explained it to my kids, like, a beer is nice. A beer is yummy and good for you once you develop a taste for it. Some people never do, and you don't have to. If you never drink a single...
They all taste the same to me.
Well, no, there's significant difference between... Like, you really couldn't pay me to drink a shandy, but I like dark lager, so there's a difference. But
I have a friend who's we both have the not allergy, the thing where cilantro tastes like dish soap and beer tastes the same to both of us. So I don't know if there's some sort of genetic thing there.
Yeah, it might be. But Ragnar says a beard is nice. You mean I love beards. I like to play with my husband's beard. I stick my fingers in his beard all the time, and he looks at me like I'm nuts. But it's fuzzy. But anyway, it's just... alcohol is not, it's not a big deal unless you make it a big deal. You drink a beer now and then, it's not a big deal. You drink a glass of wine now and then, or every day. It's not a big deal. It's not bad. It's not necessarily anything to be proud or ashamed of. It can be important to your health. You know?
But then you start getting into the 2 bottles of wine aspect, and then you're starting to get into problem town.
It's when you make a big deal out of it, when you're like, I can drink more than you can. Yes, so I drink a lot of water. I could probably drink more water than you can. You want to have a contest? It's probably not any healther. You could kill yourself with that, too. You know,
yeah, don't drown in that, please.
Yeah, don't act like this is something special or unique. It's just something that you're consuming. And doing it so much that it hurts is the same thing as hitting yourself in the face with a hammer over and over again and going, look how much fun I'm having! Boom! Ow! This is great! Boom! See, everybody, how tough I am? Why would you do that? You know, and I guess maybe my kids get a more interesting talk than everybody else, because I went into alcohol on this, and I went into cigarettes. I said, you know, why would anybody light something on fire and then stick it in their mouth? But that's just the way I look at it. So, yeah, you get blackout drunk. You drink till you get blackout drunk. That's stupid. It doesn't mean drinking is stupid. It's just stupid to overdo it, just like it's stupid to overdo anything else. You know,
moderation.
Frankly, I still don't see the sense of lighting something on fire and sticking it in your mouth, but, you know, I'm not going to stop you if that's what you want to do. On to the next one. Master Rogue gave us $2 and said, Prim! Heart, hug, smiley face. And that's adorable. And it was fun to read. And that's all of our super chats for now.
I couldn't imagine anything besides like the duck meme doing that.
Oh yeah.
Okay. So moving on.
Yeah, moving on. We have the Title IX overview, and we'll skip to the Title IX section here, where it says, no person in the United States shall on the basis of sex be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving financial assistance. And that's the 1972 version, and it included some exceptions, so frats and sororities are not in violation of Title IX. All boys' schools or all girls' schools are not in violation of Title IX, but at a co-ed school, if you say the chemistry program is all guys, that is in violation of Title IX.
Yep. Yeah, they just basically gave the brief overview of Title IX leading up until, which will, on the next slide, it'll talk about the 2011. But they also talked about the, in 2001, when things changed as well. So.
Oh, with regard to the Clery Act and the requirements for... Yeah, there has been a number of changes Title IX has gone through. Its original focus was all about not having one area of the school be men only.
Yep.
And it was basically because the public felt that, or certain parts of the public felt that universities were not catching up to the changes in the workforce, wherein more women were going into professional careers and staying there for years and years, instead of doing it for 5 years and then having babies and quitting. But I honestly think with the demand for educated women that would have come out of that over time, universities would have caught up on their own, and Title IX was never really necessary. So any feminist listeners, there's your quote mine for the day. Title IX was never really necessary, just to repeat it. And if it ever was necessary, it became outdated very soon after it was implemented. Then they started using it to attack athletic programs, and then they started using it to attack men's presence on campus entirely, and here is how. So the next slide on the 2011 Dear Colleague letter here.
Yeah, so as we all know, the 2011 Dear Colleague letter is the one that caused the most problems. It forced the school to use a preponderance of evidence standard, as opposed to whatever standard that they wanted to. So that you couldn't do mediation or informal resolutions in these types of cases. That there was no cross-examination, and that this instituted the recommended time frame of from start to end of finishing a case in 60 days. That's almost never met because that's such a ridiculously short time frame.
No kidding.
Jeez. Yeah.
Yeah. So the issues that have come up in the most recently is that the schools have been using two different standards for these types of not crimes, but these types of investigations or violations rather. So the stuff at Title IX versus what could be like an academic type thing, like you were cheating on an exam or something else in that realm. The issues that have been brought up in a lot of court cases is that you were using two different standards for on your campus when you should be using one.
Yeah, that makes sense, because I mean, realistically, if it happens on the university campus, why would you not want to treat it in a similar way? Like, that just seems obvious. Like, academic misconduct, interpersonal misconduct, it's like the people who work at a university are trained to deal with things in one way, so why are they now trying to like put on two pairs of pants and act like two different roles? It's like, you guys are not judge and jury, so stop acting like it.
It's reminiscent of the laws that have been passed to basically change how in the court of law how sex crimes are treated differently and go through different processes in the court. Like the whole can't share the woman's previous sexual history as a piece of evidence type thing. So it's eerily reminiscent to this type of thing as well.
This is something that I've harped on this before too, and I think most people know my opinion on this is all evidence should be admissible, and it should be up to the attorneys to argue to the judge or the jury what the evidence means and what its relevance really is. So yeah, a jury can hear about somebody's history, their sexual history or their criminal history, and the prosecuting or defense attorney should be able to argue, well, no, that history is irrelevant because XYZ, or history doesn't mean what they're trying to claim it means because XYZ. You know, my client's history as of getting into fights doesn't mean he's a rapist, because just because he gets into a fist fight with another guy doesn't mean he's going to force himself on anyone.
Or like if a woman is attacked in a park in the morning, and then they try to use her history of, oh, but she's slept with 50 guys, obviously that's not going to fly. But if the situation is that a woman went to a guy's dorm room after having 2 bottles of wine, and she has a long history of doing that exact same thing without complaint, then it's like, well, you know, what was different this particular time? Because, you know, that is relevant history. You have done this so many times, so what was different about this one time? I don't
I had a friend of me that was like that. She'd go to parties and she'd get drunk, and after she'd had a few, she'd grab some guy by the shirt and drag him off to some other room to fuck him. And after taking women's studies, it was before they were calling it an interdisciplinary department and all that stuff. It was just women's studies back in the 90s. She decided that she had been raped at least 50 times. You know, by guys that she had grabbed by the shirt and dragged off to another room to fuck. Yeah,
and
they were rapists now.
And does that make her feel better to think of it that way? Probably not. Like,
well, I would hope not. I wouldn't. It's not something that feels good to think about. That oh gosh, I was victimized. That is a terrible feeling. I was helpless is a terrible feeling.
Yeah, exactly. So why are they trying to push this kind of thinking? I don't understand it.
I don't know.
Those reasons.
Well, Prim, I think this next super chat is yours. You got to read this one.
Okay.
You got to read it the way you read it.
Okay. French Honey Badger gave us €5 and said, Prim, are you providing the proper amount of emotional labor? And he left out the E there, and I don't know if that was deliberate, but I was still going to read it the same way, so there you go.
There we go.
So, moving along.
Yeah, I think we
just
could
got
move to the
another
next
super
one.
chat,
We
actually.
did?
Yeah. Just a sec here. I'm going to post it, because I am not familiar with that currency, but we got a lot of whatever that
rubles,
was.
Probably.
Okay.
Rubles. That's a lot of rubles. I don't know how many dollars that is, though.
Okay, so the Void That Bites gave us 379 rubles, and thank you for that copious amounts of rubles. You get a parallel legal system. Oh, parallel legal system.
Oh, no, you get a parallel legal system. You get a parallel legal system. Everybody gets a parallel kangaroo court legal system. Hands up, yay!
That is
I did not see in time what the joke was.
You know
according
what?
to the current exchange rate, that is $5.67 US dollars.
Ruble is in bad shape. Since we get paid in sex sometimes, I'm gonna say that we got paid in rubs this time.
Awesome.
Since I'm married, I get all my rubs on my back, right between my shoulder blades there. So.
As we are all aware, in 2017, to the great ire and people losing their shit, the Trump administration, with the Betsy DeVos, the education secretary, they undid the 2011 Dear Colleague letter and basically went back to the 2001 guidance. Pissed off a lot of people. So during this, because of this new guidance, this introduced, we talked about this before, informal resolutions such as mediation, so that a person doesn't receive necessarily a judgment or whatever that would be in the Title IX world against them. It could be sorted out informally. Schools are told that they should be providing written notice to the responding party of all allegations, including sufficient details and with adequate time to prepare a response before any initial review. There have been a lot of lawsuits where students have been told, basically, hey, somebody's filed a complaint against you, and that's about it, and they weren't told any details whatsoever, and they could only basically guess at the details when they went in for their interview from the investigator to basically try and find out, so what am I exactly accused of? There was one case where the student was never actually told any of the details of the allegation against him, and he was still found guilty.
That's super messed up.
Yeah, that's why I question why universities are handling this process
to begin with. Yeah, we find you guilty, but we're not going to tell you what you did. But now we're going to take your money and you don't get an education.
Well, that's how you can tell that they're not actually interested in changing the situation to make a positive change in somebody's behavior. They don't care about that. They're just trying to, I guess, get somebody's money and kick them out of the university.
See, that's the other thing. I look at this and I'm thinking, what incentive does the university have to kick this person out of school? Because they've got their money, or to keep them in school because they've got their money. They've got an angry woman making allegations and everything.
Would probably be threatening a lawsuit if they didn't do anything.
Yeah, if they don't do what she wants. They've got all this stuff going on. They've got the political environment that they're dealing with. All of this stuff that they're having to parse and then turn around, and you've got this one guy who they think of as the source of their problem. He's been accused of something, and because he's been accused, he's the problem. It's easy to get rid of. He's the fly in the ointment. This is why I was talking about this in terms of human resources. This is what human resources does. They end up facing a similar situation where they've got an angry woman who may sue the company because of the work environment she says this guy has created, who may turn around and badmouth them publicly and get away with it, because what can they do to her? If she doesn't have any money, they can't sue her for it. And if the worst they can do is keep her from getting a job somewhere else, and that's retaliation. So regardless of whether she's right or wrong, or whether she's honest or dishonest, they're gonna favor her, because it is in their best interest in terms of avoiding other legal actions, and in terms of protecting their bottom line. And what's happening here, and what needs to continue to happen here, is men who are subjected to this shit need to ensure that these universities that are subjecting them to it know that this is also a threat to their bottom line, because it's the only thing they're going to understand. Title IX departments are nothing more than the college to student human resources department of the university system.
Yep. So they talk about this a bit later, but impartiality must be important for any of those doing investigations or people who serve on the panels. So they talk about that part later. The discretion to apply either the preponderance of evidence standard or the clear convincing standard, with the understanding that if you use clear and convincing standard for everything else that you do, you have to use it for your Title IX investigations. You can't have two sets of standards on your university campus. Appeals are not required, but a school may choose to allow appeals solely by the responding party or both parties. That's a part that I don't like, personally, because I don't feel that the complainant should be allowed to appeal the decision.
Yeah,
that kinda
it's
seems
double
a
jeopardy.
Because that's double jeopardy.
Yeah.
So I'm curious to see in the next few years, whenever the DeVos Education Department, whenever they get around to releasing the new guidance, I'll be curious to see what they end up doing with that, because we're already in the not actual legal court system. Person could face double jeopardy anyway, but facing double jeopardy within this system, the Title IX system, is just really bad. And that I feel that the respondent should always be allowed to appeal the decision. Like there
should never be a situation where you are one group of people decides your fate. And this is like I said, in terms of an innocent person, a person who did not do what he's accused of doing, the punishment involved is incredibly harsh. And in terms of a person who did do what he's accused of, if the accusation is a criminal offense, not getting to go to that school isn't all that harsh in comparison to being put in jail.
Right.
But when you're talking, either way, when you're talking about this type of trial, honestly, if the state is going to what the state's basically done here is annex the university system as part of the United States court system. And if the state is going to do that, the universities are now their own sort of copy of municipal court systems. They should have to operate under the same standards as a municipal court system would have to operate under. And the university itself, in terms of its court system, should be treated like a municipality. It should have to have its own judge. It should have to have its own jury duty. It should have to have the same rules as the court system, wherein the individual who is accused has a right to representation. And
the representation to actually be useful.
Yeah, and if they can't afford a representative, the university should have to provide them with somebody without charging them any additional fees. You know, it should be exactly the same in terms of how the court system was supposed to be set up. And their standards for evidence should not be lower than the court system standards for evidence should have to be. And double jeopardy should not be allowed. And the appeal process should. The appeal process should just go from the university system to the local court system. And that should just be the way it is. If they're going to do that, if they're going to annex the university system as part of the national court system, then they really need to subject it to the standards of the court system and make the court system the next step. So if an appeal does happen, there you go. But you know what? That's not doable. It's not a feasible thing. Which means, in all honesty, none of these hearings should be taking place on university campuses. If there's a criminal matter, turn it over to the cops and let them investigate it. Let them decide whether charges are to be brought. Let the prosecuting attorney decide whether or not that there's a case to take to court, and let an actual, real, honest-to-goodness judge and an actual, real, honest-to-goodness jury deal with the matter. I mean, because if they were going to do this right, what they're trying to do, the complexity of it is prohibitively expensive. And it's not so prohibitively expensive to stick with what we already have. We already have a court system. But let me forcibly insert a few more super chats. So we have Tyler Preston gave us $5 and said, wait, I missed one. Oh, no, I didn't. Gave us $5 and said, are you guys going to do any more Nerdcasts? I would like to hear your opinions on Netflix's Voltron series. Well, the Nerdcasts were kind of replaced by the news show, which Brian does, and that actually was replaced by HBR News. It was the Polecat Cast, and then
Pussycat Cast.
Yeah.
well, no, this was the Pussycat Cast.
Yeah, the Pussycat Cast got replaced by Talk.
But yeah, it was replaced by HBR News. We had some success with the Nerdcast and everything, but it became more and more that we were talking about news rather than pop culture. So I don't know. We might end up periodically doing things with pop culture. But
yeah,
I
sometimes
think
there's stuff that some stories like reference some sort of like TV show or movie or a video game or.
Well, we end
like
up talking about pop culture when controversy happens around
Right.
it. So there is that.
Yeah, not necessarily just what your opinions are on something, but it's when people get pissed off at something and then it's like, oh, I guess we should talk about why it's all pissed off.
Yes.
Yeah.
Or when we get pissed off about something and then we talk about it too.
That's true.
We might maybe come up with something. I don't know. But it's definitely something to send to topics@badgerpod.com as a suggestion.
It's just topic, not topics,
topic.
right?
That's right.
Yeah.
Topic at badgerpod.com. The Void That Bites gave us 379 rubs. It says that feeling when the currency bound to your VPN is borderline sexual assault. I don't know. I've never seen a borderline sexually assaulted. How do you like forcibly insert something across the borderline?
He's rubbing you across the internet.
There we go.
Yeah.
French Honey Badger gave us €2 and said, because I was talking about the federal or the federal annex of the of the university system as a court system. Like, this is what you would have to do to make this work. But the reality is it wouldn't work, because like I said, can you imagine the expense of creating municipal courts at every university? Dayton has Dayton has like 20 colleges and universities just in this location.
Don't give them scary ideas.
Well,
Yeah.
and like municipal courts, at least in like New Jersey, it's a part-time thing that like the judge is typically like a local lawyer or something from another township, and so is the prosecutor. Like, it's like in the municipal court thing, the most that they handle is like traffic tickets.
Town where I grew up had a municipal court when I was growing up there. It doesn't anymore because there wasn't enough court activity to maintain the system. But yeah,
In my town, the court operates like one day a week.
Yeah. But sometimes getting people to understand why something is not feasible takes, well, if you want to make it feasible, these are all the things you have to do. You know, you have to build this mountain, and then you have to take a spoon, and you have to move the mountain one spoonful at a time across the state to the other side of the state. Now, do you understand why this isn't going to work? You know, so you lay that out. You know, this is what would have to happen in order for this to be fair, and it's not really possible for that to happen. So there really isn't any way this is ever going to be fair, which means it needs to be abolished.
Yeah. So I guess moving on to the next.
I gotta read
slide.
Frank Tomeo's. Frank Tomeo says, "The best judges are the Italian construction workers off the street."
My God.
All right.
So I gotta say that they have some more points about the 2017 interim.
Oh yeah,
guidance
I'm gonna move to the next slide.
Yeah.
Slide on to the next bit.
The big point that they emphasized that it's the burden is on the school, not either the complainant or the respondents, to gather the actual evidence to reach a fair and impartial determination as to whether sexual misconduct has occurred. So this is where, while we were talking about the past 2 weeks, the investigator, the impartial investigator, should actually be able to get all the information. It shouldn't be up to either the complainant or the respondent to be providing everything in a hearing. The trained investigator should analyze and document the available evidence to support reliable decisions, objectively evaluate the credibility of parties and witnesses, and synthesize all available evidence, including both inculpatory and exculpatory evidence. And at this point in the presentation, somebody had asked, in a way I found weird, but they kind of made they asked them to kind of explain what exculpatory and inculpatory evidence was, because quote, they're not like lawyers, and this is like they don't operate in a court of law, so can you kind of explain this to them? So they had there was a big
That's
discussion.
the point.
Yeah, I know, right? They had to basically explain that exculpatory evidence could be anything that could help the respondent. So whether it be text messages, photos, testimony, whatever, you can't ignore that stuff.
Now, the person that asked this question, was this a university employee?
I assume most of them are, yeah.
That blows my mind. Well, okay, so they didn't know how to look at the word and look at the root of the word, and see culpable, and then X and in, and kind of figure out exculpatory might be things that indicate the individual is not culpable, and inculpatory might be things that indicate that the individual is culpable.
Where are you getting that logic from, right? Like, I mean, it's not like we're on a university and people should know these things.
Like, yeah, they're working at a university. Well, maybe they're peons who work in the office. I don't know.
Yeah, maybe
they're
it's
not professors, or
maybe it's not an English literature degree department or something.
Yeah, there's been cases in the past where schools or investigators have been biased, and they just have not. They did not bring any exculpatory evidence to the students' hearing, and it just was mind-blowing to the judge in the case. Like, how? Like, the investigator knew about this, how was it not brought to the hearing?
Especially when they don't let the student bring their own exculpatory evidence and admit it and have it considered, and they often don't allow the student to have witnesses, and they don't allow the student to have a representative, and so on. So you have this person who's been accused of something, and they may have all kinds of evidence that demonstrates that they not only didn't do it, but couldn't have done it, and yet that evidence doesn't get heard because the investigator doesn't think it's important.
So the 2017 guidance is also critical of gag orders, essentially, restricting the complainant's or the respondent's ability to talk to people, in order to say, hey, this person was at this, or like, say a person who's been accused of sexual misconduct, they find out about this and they want to talk to somebody that they were at the party with where supposedly this happened. Some schools have said, no, you can't do that.
Yeah, if only the
So
family
much for-
court system would take this lesson. This judge needs to communicate this to the family court system, in particular the areas that deal in when the government comes and takes your children away from you, and then has a hearing to terminate your parental rights. There should never be ever be a gag order on those cases, but there are all the time, especially in Canada, but this also happens in the U.S.
Yeah, so they were. Yeah, there wasn't much more added on to about that.
Gag orders are something that I think no court system should be using gag orders. Period. It's stuff should become public information once it's entered into court as evidence. Except under very rare circumstances where somebody's address becoming public information is likely to lead to them being stalked or attacked. You know.
Well, yeah, it's kind of like if everything should either be fully public or everything should be fully private. Like in cases where you have the accused and they're plastering the guy's name all over the news even before he's been formally the judgment has been heard. Like we don't even know if he's innocent, and they're still putting his name all over everything. So like in those cases, it might be better to have things be fully private. But if we're going to have everything be fully public, then everything should be fully public, not just things that are convenient.
Exactly. And then they should never be able to take somebody's kids away without that being public. They should never be able to convict a person of a crime that's punishable by jail on the word of somebody who is going to be remaining anonymous the entire time.
Exactly.
And universities are starting to get into trouble for that. They're in trouble. There have been cases where they've been found against because the accused is not only not able to face his accuser, but also the courts have handed down verdicts citing a right to cross-examine the accuser. So you're not only entitled to know what your accusation is that you're facing, but who made the accusation, and to be able to cross-examine your accuser. And frankly, that's the way it should be. You shouldn't have to face an accusation that comes from an anonymous source, where there's risk that you're going to be punished because of a system finding you culpable for that particular allegation. So, going on to the next one, the 2001 guidance, key points.
So they basically emphasized certain points from the 2001 guidance, which is basically what they went back to after they undid the 2011 Dear Colleague letter. So the guidance issued by the Department of Education for OCR in 2001 specifically incorporates principles of due process into Title IX with respect to university sexual misconduct proceedings. Constitution guarantees due process to students in public and state-supported schools who are accused of certain types of infractions. Rights established under Title IX must be interpreted consistent with any federally guaranteed due process rights involved in a complaint proceeding. Adequate, reliable, and impartial investigation completes, including the opportunity to present witnesses and other evidence. designated and reasonably prompt timeframes for the major stages of the complaint process, and schools should always be aware of these rights and their legal responsibilities to individuals accused of sexual harassment.
So this makes
Basically,
me wonder,
hey, due process is kind of important.
Yeah,
Do it.
makes me wonder
Yeah.
if at some point it's going to be feasible for somebody to sue for the use of the preponderance standard in a particular type of accusation, where were it being heard in an actual criminal court, the standard would be beyond a reasonable doubt. Because if the Constitution guarantees due process to students and in public and state supported schools who are accused of certain types of infractions, and the rights established under Title IX must be interpreted consistent with any federally guaranteed due process rights involved in a complaint proceeding, then if the standard in the federal court system would be beyond a reasonable doubt, wouldn't using a preponderance of evidence standard for that particular accusation in a university system be a due process rights violation?
One would think. But, reading these key points here for this 2001 guidance slide, honestly, it all sounds extremely reasonable, and anybody who is against it is basically just getting pissed off that they're not able to wield the law as a weapon against people that they want to use it against.
That's what I'm thinking.
Yeah.
I mean, here we have a situation where students are using these accusations as a form of revenge. They're using them as a get out of responsibility free card when they're caught cheating on their boyfriend or their girlfriend. They're using them to get out of taking tests. They're using them for attention, and they wouldn't be able to wield them as easily if they had a higher standard for evidence. The other end of it is, like I talked about last time, a lot of people are making money off of this. And if there are fewer allegations, and it is less likely for allegations to result in a finding of responsibility or culpability when the individual who's accused didn't actually do anything wrong, then they're going to make less money because they're going to be less needed. And they're going to have less hours to work and less call for demanding funds for resources and such.
Yeah. Basically, the 2001 guidance was a lot more fair. The 2011 guidance basically forced schools to try and find more people responsible for misconduct, essentially, by basically railroading respondents who are accused of sexual misconduct.
This is what happens.
Basically what that guidance did.
Yeah, and this is what happens when you go into, say, just for example, a Facebook comments section talking about, for example, say the result of the Jean Gomeshi trial, and be like, this is a miscarriage of justice because I didn't get the result that I wanted. The 2011 points were basically the result of talk like that. It's basically just like, I feel like men are not punished enough because clearly there are women who are complaining about this, and men should be punished more, regardless of whether they're guilty or innocent half the time.
Yeah,
so
the
going
idea
back
that
to-
the idea
just going
that
back to
women's
these
complaints
fair-
mean men actually did something.
Yeah, exactly. And it's not a reasonable standard to go by, because pretending like people never, ever, ever lie about these things is just not accurate. Like, you've said a couple of examples of why they do it.
Yeah.
There are reasons, and pretending there aren't is just getting innocent people, like, punished for no reason.
No, that's just it. Like my frenemy that used to, and I will continue to call her my frenemy without explanation as to why. She used to voluntarily involve herself in sex with complete strangers who were just as drunk as she was. After she went to women's studies classes, she decided she was a rape victim. She was the one initiating. She was initiating with some level of force. And I'm not going to necessarily call the guys rape victims. I think if they had turned around and pushed her away and walked away from her, she would not have pursued. But But she definitely, by the feminist standard, if the sexes were reversed, would be considered a rapist because she initiated with people who were drunk. But yeah, that idea that people are never wrong or never lie about having been sexually assaulted is absolute bullshit.
Yeah,
I've
we have
seen it
so many
enough.
examples now. And even before we had plenty of examples, but like now we're seeing many more examples being put forth. Like many of us have personal friends who have gone through it or are currently going through it.
Yep. And the effect that it has is just unbelievable. I've got friends that, well, I've got one friend who has a diagnosis of PTSD from dealing with his false accusations. That he went through over and over again, and he got arrested, taken in for questioning when they don't read you your Miranda rights, and they take away your diabetes and asthma medicines, and then lose them, and don't have any record of having taken them in the first place. That kind of thing.
Jesus.
Oh,
That's
God.
a whole lot of yikes.
Yeah, they put him in a cell for 12 hours with no food and no water after taking his diabetic medications away from him, and then said, "We didn't know he had any health problems." These are the kind of things that I see happen to people who are falsely accused of violence against women. But of course, we live in a misogynist rape culture that doesn't care when bad things happen to women. Then I want to mention Nosferatu 676's. Sorry, I'm not dyslexic all the time, just on days ending in Y. Or with Y in the middle of them, depending on how I look at them. Nosferatu 676's comment, Honey Badger Radio, I heard the DOJ is considering adding people accused under Title IX to the sex offender registry. No evidence or conviction needed, just the accusation is enough. I haven't heard of that. If you see a news story on that, I would like to know, because that's actually a huge violation of civil rights right there.
No kidding. Holy shit.
And I have my own objections to the sex offender registry, too, because my objection to the sex offender registry is really the same as my objection to the death penalty. I don't trust my government with something that damaging to our, to individuals and to our society. We find too many people who are innocent guilty of things they didn't do, and in both of those instances, people have used the sex offender registry to track people down and do them harm, and obviously the death penalty is in and of itself, it's an act of killing, and I think if we're not in a situation where there's an immediate compelling threat, killing somebody is wrong, even if they did something absolutely unbelievably mind-bogglingly horrible. Containment is the answer in that case, not murdering them. But in any case, when it comes to the sex offender registry, the whole point of it was supposed to be as a warning to the community about people who might be dangerous. And what it really seems to end up doing is it's being used to extend people's punishment following a criminal offense. So they go to court, they get convicted of this crime, they get sent to classes that are supposed to teach them not to engage in further repetition of this type of criminal offense. They graduate from these classes, and the people in charge of these classes or this therapy say, yes, they have learned their lesson, they are doing better, they have completed this program with flying colors, and they get out of jail, they've done their time, and we put them on a registry that says, well, actually they haven't done better, they haven't completed their training with flying colors, they haven't served their time, we're going to punish them for another 10 years by telling everybody in every neighborhood they move to that they're a sex offender. So which is it? Is the therapy effective? Or do we need a sex offender list? Because it can't be both.
Yeah.
So if we're going to have these... And I do believe that it's possible to to rehabilitate people who have committed heinous crimes. But honestly, I think the sex offender registry needs to be eliminated, because it essentially is an admission by the state that that rehabilitation following a sex crime, following the commission of a sex crime, is just not possible, and I think that's not true. I think it would be an egregious mistake, actually an egregious breach of trust, and a huge civil rights violation if they put people who have just been accused on the sex offender registry.
Yeah, I'm curious if that was. I did some Googling around. I couldn't find anything explicit. I'm curious if maybe that was some activist group suggesting that. I wouldn't be surprised if they suggested that, honestly.
I wouldn't either, but it definitely shouldn't happen. I mean, nobody should take them up on it.
Some people would just go as far as to say, "Oh, let's just put all men on the sex offender registry, because you never know, Schrodinger's rapist, right?"
Radfems would say that for sure. They want to have some sort of documentation they can use in order to track men down when they have their final purge, and take them down to, what is it they want to do, 10% of the original population that they will keep for breeding purposes, but that's not rapey or anything.
Like that messed up woman who was like, I can't trust any men, not even my own sons.
Yeah,
and she's talking about like these two young boys, and it's like, what is wrong with you?
Well, and there was the radical feminist who talked about how horrible men were and used her son as an example all the time. And then when her son committed suicide, she called it toxic masculinity and played victim of his suicide.
Oh my god, that makes me actually sick.
Yeah, feminists are insane. Now, granted, there are feminists that are far more insane than others, but that ideology itself is absolutely insane, and that's how we ended up with this system in our universities, is people listening to that insane ideology. So I got a couple more super chats I'm going to forcibly insert into the program. Xeranx gave us US $2 and said, "Prim, no swearing around the babies." Winky face.
Shit. it can't hear it. It can't hear anything yet. It's okay.
Yes, well, unless the baby hasn't developed hearing yet. The baby can hear everything once hearing develops.
Shit!
Hey, you know what? That was my first cuss word.
Babby is going to learn the importance of when to swear and when not to swear.
There you go. That's what you teach him.
It's an okay time.
And teach him how to use the words properly, and when they are appropriate and when they are not, and what's the most strategic use and all that stuff, and and make sure they understand that in front of their kindergarten teacher is not a strategic use.
Yes. Very much so.
French Honey Badger gave us €5 and says, "Tom Woods had a show about the sex offender registry recently with a woman recommending to kill it." Well, it wasn't me, but I recommend that as well.
Mm-hmm.
Kill with fire.
Yes, kill it. Kill it with fire. So let's see. Going on to the next.
The response.
The interim guidance response, 2017 interim guidance response, and it has a bunch of news stories here. Maybe I ought to open some of those, but it shows the headlines.
Yeah, the headlines are the
real thing.
I looked through them, and it basically what the two lawyers, when they were talking, they explained it that basically colleges really haven't changed much from what they've seen. They're taking a more wait and see approach because the guidance is interim. The DeVos Education Department is going to be going through and creating some new guidance at some point. So basically, the universities are just going to be waiting until then for the most part.
Yeah,
I don't know why they wouldn't change some things in the light of how many other universities have been getting sued and losing, or being yeah.
I'm sure they're thinking that feminists will pressure DeVos into changing her mind, or that she'll become another casualty of the tendency of Trump appointees to get targeted and removed from office. So,
yeah, I don't think she's done any. She hasn't really done anything to piss him off. I don't think so.
Yeah, it's not just Trump. It's not just Trump. This happens with like people will target Trump appointees for they'll heckle them. They'll try to get him to say and do things that'll get them into trouble, into public trouble and things like that, or dig up information about them and whatever, try to get rid of them. And I'm sure they're waiting to see if that'll happen to DeVos as well, or if she'll burn out, or anything like that, or if maybe, like I said, if feminists will get to her and her guidance will become, or if traditionalists will get to her with, you got to protect the girls, you got to protect our daughters, and this
the trad cons.
Yeah. And it's the dumb thing is, a lot of modern trad cons don't live up to past traditions. There are some that do, but a lot don't. And that's one way in which they don't, the idea of female accountability going by the wayside, that's not a past tradition. Not in the way that it's being advocated today. So, yeah, I sorry to keep clearing my throat at everybody, but it's allergy season, and this is a worse one than last year.
No.
So yeah, it's kind of messed up. I feel like I've been at a bonfire, except I haven't. I'm allergic to smoke. For the record.
It's so smoky.
Yeah. Well, I'm in Ohio, so I don't understand, why that's happening. But yeah. It's just...
the two. I'm curious to see how these two lawsuits will go. I haven't.
How they go?
How they will end up going. I haven't followed them all too much because basically they were filed as soon as the 27 interim guidance was put in place, which undid the 2011 guidance, which was put in place without a comment and review period, which is why they actually had grounds to remove it.
Yeah. Well, and to be honest, the Department of Education can change its policy anytime it wants. All they have to do is make a new policy, and the new policy has to go through that comment and review period, and it gets submitted to Congress, and if Congress doesn't pay any attention to it, it becomes policy. It's not... Which
is just baffling to me.
Yeah, there's no real oversight there. They can change anything they want. So this idea that it was okay for the 2011 guidance to come about without following even that little bit of oversight policy, but it's not okay for another policy to come about that overturns it, is just ridiculous. It's like a ridiculous lack of reading of how that policy works, of how that policy comes about. So, but going on to the informal resolution, a viable option card. So they're talking basically about, I'm gonna see if I can increase the size of this a little bit because it's
they just pulled from 3 universities, from the Caltech, Oberlin, and Syracuse, examples of ways that there can be informal resolutions instead of formal resolutions, because informal resolutions can take up very little time compared to having to go through the whole hearing process and such. That's about it. That basically, because of the reverting of the 2011 Dear Colleague letter from the Obama administration, and reverting to the 2001 Dear Colleague letter, the informal resolution is now an option that schools can use in order to save their headache.
Well, and it looks like what the examples that were cited here, the California Institute, Caltech, for violations of Caltech's unlawful harassment policy, you can choose whether to pursue informal resolution or bring a formal complaint. Informal resolution is having someone talk to the harasser, alleged harasser, and ask them to stop the problematic behavior. Leave Brittany alone. Sorry. Leave Brittany alone.
She's a human.
But that actually, I can go back to, I had this ridiculous moment when I was in junior high, where the way things were done at my school, I had lunch, and then we would go outside and stand around and wait for class to start. And we had this area we were allowed to go stand around and wait. And we weren't allowed to back in until the first bell, and then you had to be in your seat at the second bell. And there was it wasn't recess, it was just you got done with your lunch, you weren't allowed to hang around in the cafeteria, and you weren't allowed to go to class yet. So this was your place you could be. And there wasn't any real supervision. There was one student aide out there, and the area was kind of T-shaped, so she couldn't be everywhere at once. And a bunch of guys were just being dicks, and they were teasing me. And it was like 13-year-old boys. That's what 13-year-olds do. They act like jerks, and they tease each other. And so I overreacted, because there were a whole group of them, like 12. And I went in and talked to the secretary, and the secretary brought the principal in, and the principal acted like, they'd held me down in the street and raped me. And I just reacted with this ban hammer and everything. And from that, I learned that if there is a problem, you don't go talk to the authorities unless it's the worst it can possibly be, because no matter how minor it is, they're going to react to it as if it is the worst it can possibly be. And I think that's kind of the it's good if they can have an informal resolution. And if it had been me that I went in and talked to, as a 13-year-old, my answer would have been entirely different. They were playing follow the leader and doing everything I did, and I was so flexible at 13 that I could stand on one foot and lift my other leg up and throw my leg over my shoulder, and none of those guys could do that. So if I'd have done that, they'd have been screwed. But I didn't. And that was the result. So I think at universities, if they could do this, if they could take the Caltech example there and say, yeah, I'm not going to bring a formal complaint. I just want this person to stop following me around campus and asking me questions, that would be good. It would be good to have informal resolution. The idea that they got to have a hearing for every little thing. This person said this one sentence that bothered me, and I'm very upset about it, and this is why. Maybe you could just talk to that person and tell them why you're upset. Or maybe you could consider the possibility that they didn't mean it the way you're taking it. So that's
a novel
that's
concept.
Good. And then you have Oberlin. Oberlin's the university that put their reporting page where you can actually accuse somebody of sexually harassing you on out to the public, so the public could access it. And 4chan, they got accusations against Looney Tunes characters and former politicians and all of the administrators at the university, and that was great. That basically demonstrated to them that they shouldn't make it so that the entire public can anonymously make accusations of sexual misconduct against the entire public and students on their campus. They said, when the initial Title IX assessment determines that informal resolution is an option, the college will take action to end the hostile environment and to be sure the reporting party has access to all employment, educational, extracurricular opportunities at the college. Informal resolution does not involve a formal adjudication process, so it does not result in disciplinary action against the responding party. And that's important too, because a lot of times if somebody has they have a problem with another person, they don't necessarily want that person to get in trouble. They just want the problem resolved. And many, many times on university campuses, it's a multicultural environment. You have students from numerous countries attending the same university, and there may be a culture clash. And that's not a problem that somebody should be punished for. Nobody should be punished for having a culture, coming from a culture that is different from the culture of the person they're talking to, and having a cultural misunderstanding. So it's good that they have the option. Syracuse, the process through which the targeted individual exercises a desire for resolution other than through the Office of Student Rights and Responsibility or through criminal processes. Once a report is filed with the university, options for informal resolution will be reviewed with the university's Title IX coordinator, who coordinates the informal resolution process, which sounds like a whole mouthful of nothing, but basically says that they have a similar informal process to Caltech and Oberlin. Other universities really need to follow these examples in that they have these options available. If they want their system to be sustainable, if they want to continue to be able to have a process where the university deals with on-campus conflicts, they ought to at least be able to have something where the student isn't put through a trial and punishment for minor conflicts on campus. But going on, we have question, Rosin, what about due process for the accused? And,
yeah, really, what about that?
Yeah, Ginsburg. Well, that must not be ignored, and it goes beyond sexual harassment. The person who is accused has a right to defend himself or herself or himself. Sorry, this is the equivalent of 4-point text for me, and I'm not good with this. And we certainly should not lose sight of that, recognizing that these are complaints that should be heard. That's not a full sentence. There's been criticism of some college codes of conduct for not giving the accused person a fair opportunity to be heard, and that's one of the basic tenets of our system. As you know, everyone deserves a fair hearing. Rosin says, are some of those criticisms of the college codes valid? And Ginsburg answered, do I think they are? Yes. And
yes, she was at the University of Pennsylvania, I think. It was somewhere in Philly.
When a feminist like Ruth Bader Ginsburg comes out in favor of due process, colleges have really fucked up.
No kidding.
Well, yeah, even the more liberal Supreme Court justices tend to at least be on the side of due process for most cases.
Yeah.
It seems. They're not completely nuts.
And I'm just glad to see that the discussion taking place to the point where we're actually getting some agreement from like feminist judges, feminist politicians, and so on. That hey, you know what, we may have gone a little too far with this. I mean, like I said, Ginsburg, she's extremely. She's extremely left wing, and like for her to come out and say, "Hey, this is a problem," it's a hell of a problem.
Yeah.
So
especially when there was a cult around her and people were going to offer to donate their organs and stuff to keep her in
office. Yeah.
Jeez.
Jeez, Pete. I have an old pedal organ. Does that count? Actually, I don't have it anymore. So, but we did. That's the only thing I'd donate. Let's see. So now we're on to the disciplinary process from complaint to appeal, but it is 9:39, and so we're probably going to stop here, and we will go through the rest of this and maybe start another one if we get time next week.
Yeah, we're about halfway through.
So I'm going to read. Let's see. We have. I don't have. Okay, I thought I saw one about another individual, but I was misreading Tom Wood's. So with that,
from French Honey Batters before.
Yes. With that, I think I'm going to go ahead and end the show. So, unless you guys have any further input.
No, I think that we've about covered it today.
Alrighty. In that case, I'd like to thank everybody that was involved in making HBR Talk happen. Like I said, we got a lot of people working in the background on this. And I'd like to thank everybody for listening. And thanks very much, Andrew, for suffering through this horrible conference and bringing us the
this
results.
This presentation was one of the more enjoyable ones because
they're talking about reasonable things.
Yes.
Right, and especially lawyers that have represented respondents or students that have gotten kicked out of university and won.
Yeah, I think that's very important. I'm really stoked that they're listening to these people. They'll shape up if their system's going to continue to exist at all, which I still think it shouldn't. At least maybe they'll make it a little more fair and equitable. But and I'd like to thank you both my co-hosts, for being on the show. And with that,
of course.
Good night, all.